So in this case, Gaylene McDonald, Mrs. McDonald was a local artist and a member of the Cooktown School of Art Society. She paid $20 to the society in exchange for reduced commissions that she was required to pay to the society when a piece of her art was sold. She was also a volunteer of the society and in an application to the Fair Work Commission claimed that she had been bullied for 5 years, which resulted in her eventual expulsion from the society. In response to Mrs. McDonald's application, the society made a number of jurisdictional objections. These were that Mrs. McDonald was not a worker as defined under the Fair Work Act, and she was therefore not able to make a complaint to the Fair Work Commission. Number two, that the society was not a constitutionally covered business, and that even if it did employ any employees, they would not be able to bring a bullying complaint. And number three, that Mrs. McDonald had been removed from the society, so that there was no likelihood of the bullying action continuing. The Fair Work Commission found that volunteers may receive benefits in the form of reduced commissions or reduced meals or transport to and from the place where they're volunteering, but that this would not change their status to an employee. The Fair Work Commission eventually found that Mrs. McDonald was therefore not a worker under the Fair Work Act, and that she couldn't bring an application against the society claiming that she'd been bullied. The Fair Work Commission was not able to, or didn't have to, consider the other jurisdictional objections that were raised, which it noted had there was a likelihood that they would have also found that Mrs. McDonald could not bring a bullying application.
So there's a very broad definition of worker under the Fair Work Act and the bullying jurisdiction, that it can cover employees, contractors, volunteers, interns, etc. I guess the distinguishing feature in this case, as you mentioned, Alicia, is that because there was not any employees, in this case it was found by the Commission that it couldn't be a successful bullying application moving forward. I think in most of the bullying cases there are jurisdictional objections, but it's unusual to see this particular type of objection. Usually it's regarding reasonable management action. And I think in that sense it's quite an important decision, as it clearly sets out what the boundaries are in terms of that definition of worker.
The Commission referred to Ms. McDonald potentially having other legal rights. They didn't specify it. Much would depend on the way the actual business or organisation was structured, but you could imagine that potentially the expulsion could breach contract, or if it were a company limited by guarantee, there would be oppression of shareholders or members, I should say, issues that might arise. But as there was no workers at all, no employees at all engaged by this organisation, it wasn't going to be covered.